Yes.
For Professor Krasnica, regarding the prosecutorial abuse, or what I would call abuse, were those attorneys involved in that special corruption unit, and was there any way to attempt to discipline the attorneys for their conduct in the investigation and prosecution in those cases you cited?
Thank you. Actually, the Central Anti-Corruption Bureau is a specially designed state institution, budgeted from the state, financed by the state. People working at the institution, some are lawyers, some are not lawyers, and we don't really know who are the agents taking or proceeding with the investigation. And obviously there is a disciplinary procedure inside. They can be sued in the courts for the wrongdoing, right, of the investigation. The law on the Central Anti-Corruption Bureau, the Act of 2006, is very complicated and can be understood very differently. In the particular case, the first one with the doctor, right, case, they claim that everything that happened in the case was absolutely right from the operational perspective. That every action taken was right, had a good ground in the law, right, and that they could they were able to take the evidence, that it's all in the procedures and there's just nothing to be bothered by. This is how we work, right? We are not police, we are agents. Right? We work undercover. There was also an agent who seduced a nurse working for the department, right, and got her the stories from behind. This is, and now it will definitely go further with how the law, with how we should actually follow, right, with how to read the law, how far they can go, right? Where are those limits? But for the very one in the first case, in Dr. G case, I don't think there will be, the prosecution will not touch the entire procedure. It will be left as it is. The doctor himself sued the Anti-Corruption Bureau and sued particular people for calling him Dr. Mengele, for giving the operational name, for a lot of situations. He also sued some of the media for the press coverage they gave, and he won several of those cases. So there is a remedy, right? There is the right reflection. With the second case, however, with the member of the parliament case, another love story, it will continue because we'll see what the Supreme Court does. If the cassation is filed, it will be based on procedural issues. And if the procedural issues are taken out, then they will try to give back the information of how the agents worked, who were the agents, right? If there were lawyers involved, obviously they have lawyers on board. They have to say if this is legal or not. But with this particular case, the question is, the Central Anti-Corruption Bureau is able to organize a controlled bribery, a controlled action of a bribery, only if there is a reasonable background that the person would be likely to commit an offense. Where do you go with that, right? Where are the limits? We'll see what the case proceeds. But obviously the disciplinary proceedings will be given, right, if the court's verdict is in the line of the second instance court. I hope that gives you more. But
Thank you, Professor Krasnica. Professor Korolov, you have a comment.
May I ask one more question to Dr. Krasnica?
Sure.
About the second case. Can the MP seduction be interpreted as a classical entrapment case? So a kind of provocation where the MP under discussion was supposed to have criminal tendency, and then came this guy who had an order from above, and seduction was his job. Just to curb the corruption at the start. And my question is, if it is the practice, what is your attitude to this entrapment institution, Anglo-American one, actually?
Well, we'll see what is our attitude, because this is the first case that actually makes it so open and to the court. The agent, there are possible actions that the Central Anti-Corruption Bureau can take. And obviously, entrapment, whatever you call it, could be one of the ways. And again, this is not for me to judge, right? What are their priorities? But the problem was that the member of the parliament, she, in her prior files, there was nothing on her. They tested, they picked a person, and again, I would have to give you whole political background. It was just before the election.
Yeah.
And the chief of the Central Anti-Corruption Bureau, when they showed the press coverage of her being arrested, said, it should make you think, who do you vote for? I mean, it can't be just more clear. But the problem is, she was not in the environment. She was not in this illegal or suspicious environments, right? There was nothing. She was just a regular person. There was absolutely nothing on her in the files, and they picked her and worked on her very consistently for months until she broke, because she fell in love. And it's clear from the recordings that that's what happened. My attitude,
Yeah.
I would have to be very impolite here about my own country's law, but it's just unacceptable. Absolutely 100% unacceptable to test what the court said, to test the citizens' honesty. It's against the rule of law. It's against the rule of law, and that's what the court of the second instance said. It's against the rule of law. It's against the democratic state principles. It's absolutely unacceptable. So it was a huge relief to see the Court of Appeal taking the right direction. And it's still terrifying that there are people thinking about taking the case up to the Supreme Court for the cassation based on procedural issues. Thank you.
Thank you. And maybe we have time for one more question. If no one from the audience, oh, actually, there's one in back.
This question about having some experience with Lithuanian in Lithuanian courts, I see from my perspective there's a big influence and sometimes even not positive on the courts from politics and from media, especially from media when they try to somehow influence. And what's the panel's opinion about this, and do you have some experience in your country as well? I mean, is it criminalized somehow that judges under our constitution, they are judges and they can't be influenced by anyone? Somehow we see that media especially plays dirty games. So what's your opinion?
Professor Ramirez, you want to jump in at the media influence on judges in the United States?
Well, I mean, there are actually APA rules that prevent the lawyers or judges participating in the media feeding a frenzy. But we do have a First Amendment in our Constitution that allows people to speak freely about political issues. So there is this, I suppose, conflict between the freedom of expression and freedom of the press versus the rights of the accused. And so there is a tension there that we try to balance, right? We want to have the freedom of expression, but at the same time we want to protect the rights of the accused. And so it is a delicate balance, and I suppose the way we try to balance it is, again, we make rules that specifically preclude the lawyers involved in the case or the judges involved in the case from feeding into that media frenzy, but we do allow the media and individuals to express opinions, and we even allow lawyers who are not involved in the particular case to express their opinions. But that's, again, the primacy, I think, of the First Amendment right to freedom of expression. So it is a problem, but it's a problem of, again, balancing this freedom of expression in our Constitution, the right to free speech versus the rights of the accused. And it is a problem, but it's a balance.
Any other panelists want to comment on that question about the influence of media on? Yeah, sure.
Yes, Estonia is very much known as an e-country, e-governance and Skype and everything. So, but
Estonia.
yes, Estonia. Yes, exactly. So what worries me is that there are internet communities. That if there is a very sensitive case or political case, then there are communities that are actually collecting votes, and they say that in this particular case, the person is guilty or not guilty, or even they say how much, what is the sentence should be, and this is a growing trend, and a kind of worrying trend, because we have two parallel systems, like kind of customary societal understanding of justice, and then this that comes from the judicial system. That I see, and also another thing is that there are many blogs and that are commenting the judgments afterwards. That saying that this judgment was not fair, and this is also a question of media actually freedom.
Yeah, Dr. Kirchner, some quick comments, perhaps.
Thanks. Just to give you a very current example from Germany, we right now have a case which started in Munich the other day regarding a number of terrorist murders over the last couple of years. And in the run-up to this case, there has been tremendous debate. It's probably the most closely covered case of the last 20-25 years regarding access of the media to the courtroom. In Germany, it's illegal for court proceedings to be transmitted by television. So what you normally would have is that a number of places in the courtroom are reserved for the media, so that there's a possibility to report about cases. What's very common is that those places are allocated on a first come, first served basis. In this case, there have been 10 people murdered, 8 people of Turkish origin, 1 Greek immigrant and a German policewoman. And obviously there's been a tremendous interest of Turkish media in this case, yet they were not familiar with this rule. Hence, the court allocated 50 places for the media, for journalists, and none of them were from Turkey, simply because they needed more time to figure out how the system in that particular court works. The first reaction of the judges was, we are judges, we are independent, nobody's telling us how to do our work. Obviously there's been an enormous backlash, which resulted in the court deciding to assign the places again with a kind of lottery. Some of the journalists who first had a place, now after the lottery did not have a place. Some independent journalists suddenly found themselves with a place. They just tried it and hoped to get lucky and never expected to get a place, and are now essentially giving them away to big media, to big newspapers, for example. And this has a tremendous impact on the case even before the proceedings started. Thereafter the case actually started, and the first thing that happened was that the court decided to change the date for the first hearing, because the defendant, the sole survivor of this terrorist group, claimed that the judge was not independent anymore, which, after all the trouble with the media in the last couple of months, is not really a surprise. The second result was that yesterday the Minister of Justice announced that she's looking into plans to actually allow television crews to go into courtrooms, which for decades has been completely unthinkable in Germany. If somebody would have asked me even 6 months ago if we would ever have this in Germany, it would have been complete fiction, completely unthinkable from the entire tradition. And here all of a sudden we have an expectation of the media, which might now lead to a tremendous change in the procedural law. So the media not only is concerned with cases while they are being deliberated or after the decision, but now they even have an impact on the way decisions are being made even before the trial has been started. No witness has been heard in that case, nothing really has happened. The case has just been called and the date has been changed. So I think what we're talking about is not just the media as such, but expectations of the public to the way courts work.
Thank you. With that, seeing, actually, there is one other question. Sure. Actually, just to be polite, a very quick question would be good.
Profesorius Vangilės, galbūt galima paklausti. Ar gali, vienas iš pavyzdžių buvo, kad atsisakė advokatas atstovauti ten vienoje byloje, o kitam advokatui tam tikros informacijos nepateikė klientas. Ar gali Jungtinėse Amerikos valstijose be jokių apribojimų laisvai atsisakyti atstovauti asmenį advokatas, tokį asmenį, kuris jį kreipėsi kaip į profesionalą, prašydamas atstovauti? Ar yra kokie nors apribojimai, tik tam tikri atvejai, kada galima atsisakyti? Ar tai gali laisvai?
I will translate. Judge of Constitutional Court is asking you, because one of your examples was that attorney rejected to represent the client. So he is asking whether it is possible in the United States without any restrictions for attorney to reject representation as professional.
Yes, absolutely. In the United States, the attorney is not seen as a public public institution. That is, as attorneys, we're free to take whichever clients we wish to take. The only exception to that is when we are assigned by a court to take a particular case. There are cases where a court may assign you to take a case for an indigent client, that is a client who cannot pay for an attorney. You may be assigned, and we have then a professional responsibility to represent individuals who cannot afford an attorney. That is a moral responsibility that we undertake, because we basically have a monopoly over there is no one else who can represent individuals before courts except those who are licensed to practice law. And because we are licensed, we basically have a monopoly to represent. And so in cases where individuals cannot represent, it's our duty to represent for free when assigned by a judge. And in a certain sense, we have a moral responsibility to represent individuals on our own who come to us and who cannot afford. And that's a moral responsibility because, again, our duty is as someone said, is not just to the client, but to the rule of law itself. And the rule of law demands that each individual have representation, and therefore it's a moral responsibility for us to represent individuals, even those who cannot afford. So the one instance where we do have to represent is when a judge assigns us to. It would be very, very difficult to refuse a judge who asked us to take on a case. We could refuse if there was some kind of conflict of interest. In those cases, we could refuse, but generally it's very, very difficult not to accept an appointment when a judge tells us to. But other than that, when a client walks through my door and asks me to take a case, I have a right to say, no, I don't want that case for whatever reason. I may disagree with the opinion. I may not believe he has a good case. I may not believe in the ethics of the particular position, but generally I have a choice.
Okay, thank you, Professor Ramirez. And with that, since we're running short on time, we will end the questioning. We'll reconvene. We'll try to reconvene at about 1:15, if possible. So that will keep us just about 15 minutes behind schedule. So at 1:15, we'll come back with the second session. And please just join me in giving a hand for our excellent panelists today.